Hi, everyone. We'll make a start in just a moment. I'll just give another minute for people to choose their breakout rooms before we get started. Thank you. Okay, great. Let's make a start. So hello again, everyone, and welcome to our final panel. This panel will look at the relationship between the media and international law. Now, I think it's fair to say that this relationship can be described as multidimensional in the sense that the media has the capability to act both as an object of international legal regulation as well as an influence on the development and structure of international law. Now, this relationship has only been made increasingly complex and also increasingly important in the face of globalization and digitization, and the rise of social media and other digital media platforms has also added an additional layer of complexity to the equation. But in spite of the clear and obvious connections that we can see between the media and international law, this relationship and its implications have only been the subject of a little bit of consideration in the existing literature. So I'm really excited to hear from our panelists today. The three presentations that we'll hear on this panel aim to critically engage with the nature of the relationship between the media and international law and address some of the questions, challenges, and issues that it has presented. So we'll first hear from Henning Lahmann on the media's emerging role in counter-narrating state conduct with digital open source information. Second, Marko Spicevic will present on the media's influence on public perception in international law, considering specifically the example of the UN Security Council. And finally, we'll hear from Maria Bellin-Paoletti and Ivan Levy, whose presentation will explore the impact of online platforms on the validity of unilateral acts in international law. Now, each panelist has around 15 minutes to present, which should leave us with just under half an hour at the end for a discussion period, during which we'll invite questions from the audience and from the panelists to one another. But if any of you have questions that come up during the panelists' presentations, please feel free to leave them in the meeting chat and we can return to them at the end of everyone's presentations. So with that out of the way, I'd now like to hand over to Henning Lahmann for his presentation. Thanks so much, Henning.
Yeah, thanks so much, Georgia. Where can I share my screen?
You should have an option on the bottom toolbar of Zoom that says share screen.
Oh, yeah. Thank you.
No problem.
All right. Thanks again for having me. So I'm going to talk about the emerging practice of the media to utilize digital open source information that we already heard about in the very first panel, and uses that to ask larger questions about how facts are being produced in international legal discourse. Because if we conceive of international law as an argumentative practice mainly, we still have the very, the very unique situation is compared to other legal contexts that much of this discourse is happening outside the courtroom. So we don't have compulsory jurisdiction of courts the way we have in domestic legal contexts or in the context of the European Union, for example. But most of this discourse is happening outside of these like formalized judicial proceedings and settings. But still, we can observe that states use international law language all the time. First of all, of course, to legitimize their action, to claim that they do act legally. But then, as we've heard already, and also in a different panel, in international relations theory, we have this approach of constructivism that also says that the more we use international legal language, the more or the more states use international legal language to justify their conduct, the more the norms are being stabilized. So we need this kind of discourse to stabilize the norm and then also the system of international law. But as we know, a lot of what happens also is that states try to evade this justificatory discourse anytime they act in secret, they act covertly, or even if they act illegally. So they try to justify their behavior either by manipulating the facts, by lying about the facts, or by constructing a factual narrative that is not truthful, or if they have done something wrong, that they afterwards try to hide the facts, to obscure what has happened, or to simply deny that anything illegal has been happening. So then the question is, in this context, when can we speak of a fact for legal discourse? Because of course, at the end of the day, legal discourse is applying the law to a factual situation. So we need not just the legal side, the interpretation of the law, but also we need to establish the facts in order to have meaningful legal discourse that can then unfold and have these norm stabilizing effects that the constructivist scholars have been talking about. And in domestic settings, it's very simple. We have courts that establish what the facts are at the end of a judicial proceeding. But in international legal discourse outside of the courtroom, that's not really clear what we do to establish these facts, which is one of my main overarching research questions. And then what relates to that is the question, when do we accept in those settings, for example, in the Security Council at the United Nations or at the General Assembly, when do we accept factual claims as actually having been established as facts? What actors are involved in the production of legally relevant facts? And of course, what I'm looking at there is especially the media. I'm going to get to that in a second. So as I already mentioned, states make factual claims all the time in order to justify their conduct. This is an example from 1986 when after a terrorist attack in Berlin, the United States bombed Tripoli, and there was a discussion about that in the UN Security Council afterwards. And the US tried to justify their conduct, this use of force against Libya, by pointing to covert evidence, secret evidence that they had obtained, ostensibly had obtained through their intelligence services. And this is something that we've seen all the way through the UN history, that even if states make factual claims, they usually don't disclose their sources. They usually don't know, say how they know what they pretend to know in these situations. And this, of course, leads then on the other side, as we can see here from the quotes, to a lot of skepticism from other states, justified skepticism, that they are being lied to. As Simon Chesterman said in 2006, when isolated pieces of information are shared without the source being disclosed, a reasonable response for other actors within this discursive setting is, of course, to suspect that they're being manipulated, to suspect that they're being lied to. And I think we've all have a lot of examples at hand of how this unfolds. We just had this also in the context of Russia's justifications for the invasion of Ukraine, where they also put forth a lot of factual claims about an unfolding genocide, for example, in eastern Ukraine against Russian speakers, and all these things to justify their invasion. Because of this a situation where the states make factual claims without disclosing the source, without disclosing any concrete evidence, we've always had third-party actors to a large degree, much larger, I would argue, than in domestic settings, in a substitutive or at least in a complementary function to help establishing the facts for the context of legal discourse. And here we have especially the media that has always fulfilled this role of establishing the facts also for other actors, for states that might not have the same intelligence capacities or just are too far away from the situation to establish their own facts with their own means. It's always been the media that has been reporting on these facts and in that sense had this complementary role. But until recently, I would argue, the media kind of faced the same problem that states faced when it came to these factual claims, because they too were to a large extent dependent on things like leaks, on undisclosed government sources in their reporting, on witnesses. So as Alexandra Perina phrased it a couple of years ago, they were also just dependent on the facts that were made available to them. So they also had to trust their sources, to trust the states, the governments that were relaying those facts to them, and didn't have their own means of necessarily their own means of storytelling in the sense to establish these facts. And because of that, what we've also always seen over the course of the decades was a lot of co-opting of media by states to put forth their own interests, to support their own agendas. We had this here in the Cold War, when Kennedy said, like, the media should ask itself, is it in the interest of national security before reporting something? But of course, I think the most striking example of the past 2 decades was what happened in the run-up to the Iraq war in 2003, when the media was really, despite a lot of, let's say, not evidence, but information that pointed in a different direction, were co-opted by the US government to follow the government line of these purported weapons of mass destruction in Iraq, those purported links to Al-Qaeda from the Iraqi government. And this was, I think, the result of this circumstance that they also could not necessarily rely on other pieces of information that were not related to them. Of course, this is not a completely two-sided argument, but it's, I think, to a large extent true. Because of that, also in legal discourse, we always had a big skepticism towards considering the media or press reports as actual evidence. Of course, we use this information for the purposes of discourse, but when it came to actually accepting the media reporting as evidence, so you can see here, of course, this is now an example from a judicial setting, but the ICJ formulated this very precisely, this like big reluctance towards the media as producing facts that could be used as a trustworthy, reliable source in legal discourse. But what I would argue now, what has happened over the past 5 to 10 years is the emergence of a new paradigm in this arena with the emergence of this digital open source evidence that we've already heard about. So because of the digital transformation, we suddenly have this ubiquity of evidence in the public domain, audiovisual material, on social media, geospatial data, satellite imagery, all these pieces of information that now mean that these third-party actors, of course, also NGOs, civil society organizations such as Bellingcat, for example, we heard about them, but especially the media, do not have to rely on these leaks or undisclosed sources anymore to the same extent. So we really have a new, I think, a shift in how facts are being produced for the purpose of legal discourse. And because of that, we now have in the media more and more publications, more and more organizations that dedicate vast resources to these new types of investigations that we didn't have like 5 to 10 years ago. This is an example from the New York Times, but the BBC now has a unit to verify facts in this way. I think The Guardian, Financial Times, a lot of these outlets now have these new types of investigations that in a very different way now produce these facts. And I think also other actors now react to this type of reporting very differently. What I find very striking, and we talked about this in the first panel, the question of verification, what I find very striking here is this idea that not all follow, but more and more, this idea of open verification. So that we don't just present reporting to the audience like a finished piece of investigation with some asserted fact, but we put the individual pieces of information that we use to create this narrative, to construct this fact, into the open for others to verify, for others to comprehend, and to check their authenticity and their accuracy, which is a direct response to this critique that I mentioned, that the media was also just relying on leaks and undisclosed sources, that no one really could follow where these investigations came from. And we had to trust them for their reporting. So now we have this principle that presumes that the recipient should be able to, at least to some extent, be able to verify by themselves how a piece of evidence came about. We have like more and more of these investigations. This is just one example from 2 years ago, where the New York Times uncovered, with this type of evidence, this open source evidence, this unlawful drone strike in Kabul. We had the same in Syria. Of course, there are more and more examples also from Gaza now that we might be able to address in the discussion. So, and of course, the whole context of Ukraine and Russia had seen a lot of these reportings when it came to war crimes, but also the justification of the invasion itself. So what I'm focusing on in my research, and I'm still very much in the beginning, is the question of how does a state that is confronted with such type of counter-narrative that exposes its wrongdoing, how does it respond to that kind of investigation? Does it change its legal narrative? Does it change the justification? Does it double down on denying? We've seen all these types also just in the last couple of weeks. And much more importantly, also for this framing of legal discourse that has norm stabilizing effects, how do other actors respond once a factual claim has been accepted as fact in this way? So how do these actors then incorporate this into their legal arguments against the norm violating actors, and how can we then observe norm stabilizing effects because of that? So this is really what I'm mostly interested in. This requires a lot of empirical research that I haven't done yet. And just at the very end, I can't show all the slides that are related to that. But of course, as I mentioned, we've seen in the last couple of weeks a lot of new developments, I think, in this direction. So one of my questions that I had is, under what conditions do open source investigations run the risk of creating merely the illusion of factuality? When we see what happened with the incident at the Al-Ahli hospital in Gaza, where we had a lot of this type of reporting from different media outlets, but actually a lot of this reporting, even though it used these methods and it used applied the principle of open verification, that they came to completely different outcomes. Who was responsible for this atrocity at the hospital? And also, what are the overarching dangers if we focus on these like incidents, these singular incidents? Do we maybe lose focus of the larger context that we need to focus on when it comes to legal discourse? What I've also been observing in the last weeks is that how like states now respond to this type of practice by also using this same type of aesthetic language of open source investigations, by also putting out ostensibly putting out this type of evidence to bolster their narratives, to justify their actions. this we've also seen in Gaza now a lot. So you can see states now also reacting to this practice. But I think I'm going to leave it here for now. And thank you for listening.
Thank you very much, Henning. That was very interesting. We'll next hear from Marko Spicevic. Marko, if you would like to present, that would be great.
Thank you very much. Thank you for having the panel and for the organizers for all the organization. I'm just going to try and share the screen. Okay, I hope it's all good. Okay, so thank you very much again. And the presentation that I will do will examine how the Security Council has been portrayed in the media. So it's going to look at this examination all the way from the inception of the United Nations in 1945 to the present day. As will be seen, the Security Council has had a turbulent 78 years, and naturally much of this has been reflected in the media. What we can observe at the outset is that media coverage of the Security has followed its discourse from a hyped up beginning with a hope for world peace to a very, very quick realization of the realities within which the Security Council functions. And that is that it's a political body, often incapable of tackling some of the most pressing challenges of the day. And to this end, there has been a consistent shift in how the Security Council is viewed in the media, usually a back and forward shift from hope to failure, from failure to hope. And I would argue that with the most recent events, not only with the situation in Ukraine, but also what we currently see ongoing between Israel and Palestine, I think we've actually come full circle with this back and forward, the Security Council's presentation in the media. Just want to check, are the slides changing?
It hasn't changed, Marko. It's still on the first. There we go.
Okay. So I'd like to therefore go straight away into the adoption of the UN Charter in 1945 and the establishment of the Security Council, which really set the stage for some grand expectations. So, of course, with the adoption of the UN Charter, one of the most widely publicized aspects of this new United Nations organization was the Security Council. While the Charter was seen as the basis for world peace, the Security Council was seen as that sole body which really was responsible for such peace. The magnitude of such an event was obvious. A new organization which aimed to do what the predecessor, the League of Nations, had failed to do. From its very inception, therefore, it must be stressed that the Security Council was really bestowed by some unrealistic expectations. And if we look at the media coverage, even during this time, or especially during this time and further on, we can see some of that extensive coverage of and setting the stage for really what could be argued as some very high and often unrealistic expectations. The occasion was not only considered monumental, of course, but it inadvertently set the stage for the organization to almost, in a sense, fail at these expectations. Despite the fact that so early on the modalities and technicalities had not yet been worked out, a message of positivity and post-war setting had been drawn up already. The Security Council's bar had been set exceptionally high, and its initiation had been framed as a collective organization which would ensure that situations of war were not only prevented, but that those which did arise would actually be dealt with swiftly and on the basis of collective decision-making. Now, to the end that it should be mentioned, the coverage of the Security Council's inception was nothing short of a positive plan of action. Correspondingly, the Security Council's initial coverage was that of lightheartedness and optimism, a very pragmatic approach. The Security Council had indeed been painted as a beacon of hope. And this beacon of hope extended also to the broader reception of the Security Council. a body which was considered as having contributions from all nations in good faith with legitimate undertakings to ensure its proper and well-functioning status. And that status, of course, is for the maintenance of international peace and security. Now, with that said, and with these expectations set, it became very quickly clear that that there was going to be some really big challenges that the Security Council would have to overcome, and that these challenges really came about very, very quickly. Surprisingly, the first instance of unease within which the Security Council found tension in was, of course, between the permanent members. A common theme which would arise numerous times over the years. While initially reporting on situation-specific disagreements, at least within the media, the veto power became a particular focus in the media, owing especially, of course, to the strategic impact it would have on the collective decision-making of the organization. Had these initial reports been a symptom of what was to come, the perception of the Security Council during the Cold War years would render it paralyzed, if not entirely lifeless. Now, diagnosing the Security Council's failure at the time and during the entire Cold War period was well merited, but especially because the Cold War represented the longest period of time that it had continuously failed to address a number of different situations related to international peace and security. And these are numerous in scope, from Soviet walkouts to the expulsion of China. The Security Council was, of course, plagued by disagreement, not only disagreement, but hostility, and, of course, dozens of uses of the veto. And it is this period which I think contributed most to eroding the image of the Security Council, both within the media and the public at large, because we had initially this major inception of hope for peace, and then a sudden and very daunting realization of the realities within which the Security Council would be functioning in. And of course, usually that means political realities, which would often trump the Council's abilities to act on many situations. At the same time, despite this media coverage of the Security Council, particularly during the Cold War, it should be noted that the Security Council's achievements were also highlighted. Major actions, specifically, for example, the first authorized the use of military force during the Korean War, was covered extensively. And for a brief moment during these periods of coverage, there was a hope that the Security Council had returned to a normal functioning, or at least what would have been dubbed in the media as a normal function. Of course, it should also be mentioned that these moments were painted very carefully, without precise details of how or why the Security Council was able to intricately deal with certain situations. And what followed on from this period was, of course, the later half of the century, which seemed to affirm what was painted earlier on, that the Security Council had been worn down by the members that were composed, or that composed it. Despite moments of brief pause, the Security Council's failures continue to make headlines, not unjustifiably so, given the numerous situations that it had been unable to address effectively. It is precisely for this reason that the Security Council has become synonymous with failure. Considering its past reflections of such, one has to wonder even today if we're not seeing this similar or same pattern, an era when the Security Council is seen as a failing organ. Headlines broadly painted a thesaurus of words. The Security Council is a failure. The Security Council has failed. The Security Council is failing. News headlines and articles paint an almost synonymous picture between the UN Security Council, which importantly it's often termed simply or collectively as the UN, and that of failure. The Security Council failed to agree on this. It failed to adopt that. Sometimes the Security Council is painted as being paralyzed or has become non-functional. And the broader, sorry, just another one. In the broader picture, one needs to make a very strong observation with all these failures of the Security Council. And that is, firstly, A picture of the Security Council's failure is usually linked to a specific situation and not generally to the functioning of the Security Council as a whole. In this regard, of course, the failure of the Security Council to act on a specific situation, sometimes even a single situation, is often extrapolated as a general failure on the Security Council to fulfill its matters of maintaining or restoring international peace and security. Secondly, a repeated failure of the Security Council, sometimes even rightfully so, on certain situations, gives a broader impression that the Security Council has simply failed in all general functions that it has, rather than the fact that it has failed on a specific situation, or even the fact that it simply failed to reach consensus on that specific situation. Naturally, these specific situations usually concern the interests of the Permanent Five. And of course, what we need to consider again is that as a political body, it remains unrealistic to expect the Security Council to reach a consensus across the board, or to even reach a consensus on every single situation that it may consider or tackle. And thirdly, it's worth noting that the Security Council has a habit of failing to act on a number of situations. But this extrapolation of its failure on specific situations to its functions, broadly speaking, is arguably without merit. And I'll get back later to why I say that. Now, the perception that the Security Council has failed maintaining international peace and security has had quite a few consequences. The most detrimental of these is that the failure of the Security Council is often attributed to the entire UN system. When the Security Council fails, this is often reflected as a failure of the United Nations as a whole. Another consequence of the ups and downs of the Security Council is that it has been set incredibly high expectations that in future it may be unable to meet as a matter of practical reality. The Security Council, after all, is a political body, and despite the far-reaching powers it may have even under Chapter 7 of the Security Council, it can in practice do no more than its members' will. A will that is no doubt based on the political interests of its member states, in particular the P5, and by extension, the national interests of the P5. Another consequence of the perception of the Security Council, combined with the high expectations placed on it, involves unrealistic or impractical ideas about procedural aspects of its functioning. There are now, as we've seen before, suggestions that one or more of the Permanent Five members can be suspended or expelled from the Security Council. This on its own is quite unlikely. Another idea that has come up over the time is that the Security Council can be meaningfully reformed. Again, quite unlikely, or at least not without major concessions. Another idea is that we could increase the number of seats of the Security Council, which we should recall has only ever happened once, or removing the veto from the Permanent Five members completely. Of course, another idea that's quite or highly unlikely. Of course, with the end of the Cold War, the 1990s saw a return or a move away from the Security Council's failures to a more hopeful or optimistic view of the Security Council. Now, this renewed hope was well merited at the time, given that the Security Council was able to reach consensus on many, many issues, particularly during the 1990s. Now, the 1990s included, as well as the first decade of the 21st century, proved that the Security Council's most active and even proactive period. Of course, this was evident not only from the number of issues and new issues that it was able to address, but also the number of resolutions it was able to approve that dealt directly with pressing matters, including such as the situations in Bosnia and Herzegovina, Afghanistan, Iraq, Somalia, the Great Lakes region, and Haiti. And one has to say that it would seem, from the second decade of the new century onward, there seems to be somewhat of a reversal in the view in which the Security Council has been seen. And I say this particularly with the situation in Ukraine, but also more recently with the situation in Gaza. We see that these recent events suggest that we have made a full circle. We have now gone back to the perception that the Security Council is yet again a failure. Its inability to address substantively major conflicts now seems to again be attributed to the entire Security Council's functions and to the entire UN as again a reflection of a failing organization. So consequently, we see again a massive emphasis on failure based on situation-specific circumstances. What this has in turn, yet again, is a repeat of expectations of the Security Council, which reflect unrealistic or impractical conclusions. This may simply be a recurrence in how we view the Security Council's ability or even inability, and it may also be a reflection to some extent of how desperate some views have become on the Security Council. With that said, however, I would like to move away from the pessimistic note and conclude with a much more optimistic view. And that is that even the footage that we, or sorry, rather the coverage that we see today is no way a true reflection of the body itself. And I would like to bring up the quote by Thomas Weiss that the rumors of the UN's death have been greatly exaggerated, and by extension, the death of the Security Council as well. First of all, the Security Council is alive and functioning. We only need to look at recent events where the Security Council has acted on certain situations. Just, I think, 2 weeks ago it was, the Security Council renewed Operation Althea in Bosnia and Herzegovina, which unfortunately did not receive so much coverage. In that same vein, the Security Council just recently authorized a deployment to Haiti, one of the first of its kind in the last decade. So certainly the Security Council is still functioning. It's true, the failures of the Security Council often overshadow its successes, but that does not take away from the Security Council's successes. And to that end, we should certainly not attribute the failures or the reflection of the failures of the Security Council to the United Nations as a whole. The Security Council has achieved far more than it has failed to achieve. Historically, we can simply look at how much the Security Council has been able to achieve. It has deployed some more than missions across the world, and many of these were peacekeeping missions. We currently have 12 ongoing peacekeeping missions. Some of them have been authorized to use force. And with these 12 peacekeeping missions, we need to keep in mind that their mandates require either annual or every 6-month renewals. And somehow the Security Council is able to get together and approve the extensions of these mandates on a quite consistent and a regular basis. So we should also keep in mind that there have been some 30+ military operations authorized in various conflict situations, Haiti being the most recent one. And of course, last but not least, the Security Council has taken a number of landmark decisions and adopted some landmark resolutions, such as those dealing with children in armed conflict, women, peace and security, tackling of piracy off the coast of Somalia, the issue of non-proliferation, the issue of migrant smuggling and trafficking. Not to mention the Security Council's numerous ad hoc working groups and sanctions committees, through which it puts a tremendous amount of effort and resources that it directs, which in one way or another ends up contributing to its core function of maintaining international peace and security. So to conclude, therefore, the reflection of the Security Council's functioning in the media may be dire, especially nowadays where we have this return to seeing the Security Council as a failure. But its work on the task of maintaining international peace and security, naturally a task that has no end, is ongoing. So thank you.
Thanks so much for that, Marco. That was very interesting. Our final presentation for this panel is from Maria Bellin-Paoletta and Ivan Levy. So I'll hand it over to them.
Okay, let me see if I can share the screen.
Hello, everyone. Thank you for having us. So while Ivan starts to share the screen, we'll just start with the presentation.
Okay.
So, can you all see it now?
We can.
Great.
Off you go.
Great. So we'll start by stating that unilateral acts, we might be referring to them by unilateral acts or by UA, so that we don't bore you with the same definition over and over again. But yeah, unilateral acts have been for a significant time a notable topic in the field of public international law as well as international relations, but perhaps it has not been the most extensively researched. So as the name implies, these behaviors frequently involve unilateral declarations, statements, and decisions made by government officials on behalf of their state. So these officials, by virtue of their roles, serve as state representatives and can consequently trigger state responsibility under public international law. So this is indeed undeniably one of the fundamental attributes that define what UAs are, as they possess unilateral binding power, which means that their legal validity is derived solely from the unilateral act itself, without being contingent to any sort of reciprocal act or declaration from another state. So while it can be acknowledged that the validity and enforceability of UAs are grounded in the fundamental principles of good faith and pacta sunt servanda, today's era of rapid technological advances and globalization has created unprecedented ways of making these statements public. Historically, unilateral acts would only be valid if publicly known. So certainly this requirement for them to be valid is nowadays delving into previously uncharted territory, as it is being prevalently channeled in the realms of social media and online platforms. Okay, so moving on to our next slide, we'd like to present our main argument for this presentation, which is that the social media platform's role in facilitating the disclosure of unilateral acts made by state representatives on social media is paramount to enhancing their legitimacy, which in turn has significant implications on state responsibility under public international law. The absence of written and universally binding international laws on these scenarios possess, we believe, significant challenges related to admissibility, lawfulness, dissemination of misinformation, and the overall potential reactions that the international community may have in these circumstances. So in light of these challenges, we will propose a set of suggestions for the creation and broadcasting of unilateral acts via social media. So one of the things we wanted to talk about is this rise of digital diplomacy. Since 1945, public international law has undergone, we believe, substantial growth and continuous development, and this is a trend that we believe persists nowadays. So this phenomenon is especially evident as the roster of entities recognized as public international law subjects continues to expand, and contemporary advancements in travel, in communication, enhance the interactions between international actors. This is simultaneously evidenced by what happens with unilateral acts themselves, which have evolved and broadened in scope, becoming a widespread means by which some states internationally conduct their relations. This is why we believe it is essential to understand the evolving nature of unilateral acts in the context of social media platforms, and moreover, their implications for public international law and international relations. This is because UAs in the current digital age encompass not only traditional declarations and formal statements, but as we're seeing nowadays, they can also involve posts, tweets, and multimedia content, which are disseminated through official online platforms. And as technology advances, consideration then should be given to the extent by which states can undertake any commitment. So, what is the role of social media platforms in disclosing unilateral acts? The role of social media channels within the international relations landscape, we believe, is undeniable. In an era where these channels tend to be the first ones to reach people across countries and generations even, their significance in setting the global agenda and shaping international events portrayals should be recognized. So considering unilateral acts, its impact extends even beyond the dissemination of information, because they include the possibility of influencing general perceptions, public opinion, and most importantly, the reaction of other states to said conducts. As social media platforms provide government officials with direct and unfiltered communication channels, we believe that a double-edged sort of situation can arise. While transparency, immediacy, and direct communication with the international community may be facilitated, the rise of risks related to the accuracy and responsibility of such communications should also be factored in. This is important because this scenario is fueled by the rapid dissemination of information through social media channels, which leaves almost little to no time for careful consideration and legal review. Also, the informal nature governing these platforms can also sort of blur the lines between official statements from states and its representatives' personal expression, which could raise further questions, we believe, with aspects regarding accountability, the rule of law, and potential spreading of misinformation. Finally, the international community's response to unilateral acts made through digital networks can be swift, can be unpredictable, and social media channels can contribute to amplifying reactions. This is a very important aspect of social media, which could lead to significant diplomatic and also even geopolitical consequences. We have suggestions. So our suggestions for the dissemination of UAs in social media are the following. One of the main aspects that we believe that should be considered is the ex-ante legal review of these conducts. Considering that UAs only require publicity to be valid and hold thus no other formal requirements, the focus should be on the content of the declaration that the state's representative is willing to display. So for these reasons, the state could, for instance, establish internal procedures to undergo previous legal scrutiny and formalization of unilateral acts made by high-ranked officials through social media platforms. Some states do nowadays have these kind of procedures, and by adding this local in-state protocol, it could help ease the unrestrained immediacy that these channels provide with the sort of the outside world. The second suggestion is that state representatives and high-ranked government officials should also clearly identify their social media statements as official communications. This practice, we believe, would bolster transparency, would provide a clear demarcation between personal opinions and state policy, which is a very important aspect. And naturally, this distinction is particularly critical in situations where the boundary between the two is quite delicate. So this would leave room for various interpretations, which is something that we would want to avoid. So following the previous suggestion, states could employ digital diplomacy strategies to engage with the global public. So, for instance, this could include providing context, providing information and clarification on the unilateral act itself to prevent the spread of misinformation. by providing accurate context and authoritative information, states could, we believe, guide the interpretation of their own unilateral acts, curbing the risk of misinterpretation that might or could lead to unforeseen and potentially detrimental consequences in the realm of international relations. And finally, there should be efforts made to develop international law or soft law instruments addressing the use of social media for unilateral acts. There's a study made because while the International Law Commission has created, we believe, more or less after 10 years of studying the topic, the guiding principles applicable to unilateral declarations of states capable of creating legal obligations. This is the name of the soft law instrument. It could be argued that, as its preamble suggests, this is a set of non-binding guidelines that relate only to UA's stricto sensu, would say, like those, meaning those who are taking the form of formal declarations formulated by a state, which cannot be necessarily the case for the scenarios that we are analyzing here in this presentation. Okay, so final remarks. We wanted to conclude that the impact of social media platforms on the public disclosure of unilateral acts is indeed a very complex and evolving issue. While UAs generally remain valid and binding, the digital age has introduced new challenges related, as we said earlier, to admissibility, to lawfulness, to misinformation, and to the international community's overall reaction to this way of displaying state conducts. So to address these challenges, we provided a very sort of small, but we believe solid set of guidelines and suggestions for the creation and dissemination of UAs through social media channels, emphasizing in any event the role that online platforms play in these scenarios, and the need for further development of at least soft law instruments that specifically target these scenarios. Undoubtedly, the role of social media channels in the international relations realm should be recognized as an increasingly influential part in the shaping of the global discourse and state actions. To conclude, in an era of rapid technological advances and globalization, the relationship between social media channels, unilateral acts, and international relations, we believe, should be constantly reevaluated and adapted to ensure legitimacy in the international order. So thank you very much for listening. We will gladly answer any questions you may have.
Thank you both for that presentation. We'll now open up the discussion period. So if any of the members of the audience or any of the panelists have any questions for one another or for any of our panelists, please feel free to raise your hand and ask them directly, or if you'd prefer to, you could post a question in the meeting chat and just let me know who it's addressed to, and I can read it out loud for you. So if anyone has any questions. Great, we have one from Rigmor. Would you like to ask your question?
Yes, thank you. Thank you all for the very interesting presentation. So my question goes to the last presentation. I found it interesting, and I have recently been thinking around the concept of tempo in relation to, you know, information flows, basically, including those that come from the social media. So my question would be to you, what do you think is the main problem you would try to address with for instance, as you mentioned in your how do you say, summary, soft law instruments to regulate social platforms. So what is the key problem you try to solve? I mean, I agree with you. There's a huge problem, but you know, if you try to dissecate it.
I don't know if you wanna say something.
You can start and I can add to what you say.
No, I think it's difficult to make a ranking, say there's one problem. I think you could see different problems depending which point of view you take. I mean, do you want a state to prevent incurring responsibility? Meaning, do you want a state to be more cautious and try to avoid getting into a situation where some sort of commitment may have arisen? Or do you want to try to protect the population from getting information or assuming that some information that could have been an opinion could have some background of information about what a state is willing to do or what a state is planning to do? So I think making a ranking would be a little difficult. Of course, different stakeholders can have different priorities. I agree on that. From a state perspective, you would say trying to avoid any liability would be very important, and that's why Ben was saying this thing about the ex ante controls and how you would want to avoid a situation as the one in Eastern Greenland, right? Having a state representative, say something that goes against a claim that you wanted to make as a state. Although I could argue that in Eastern Greenland that was irrelevant to the final result of the judgment, but we can leave that for a different discussion. But depends which stakeholder you have a look at. If I were in an NGO looking for transparency, then I would be very, very much pushing for some system that could help society understand what could be an opinion versus what could be some real interest of the state, some real commitment, some real strategy. I don't know if you want to add anything.
I think that was great.
Excellent. Do we have any other questions from the audience or from the panelists to one another? Yeah, Henning.
Yeah, thank you. I found both presentations really fascinating, and I hadn't really thought about any of that. I have a question for Marco. It's so interesting what you were saying about how the public perception is being shaped through the media. And maybe I missed that in your presentation, but like going forward, do you think the media could do a better job at like informing us all about like what the Security Council is for and what it's doing, and then more about like the system itself, like because like especially now again, like over the past weeks with the conflict in Gaza, there has been again like a lot of coverage, of course, on the UN and what it's doing and what it's not doing, and you mentioned this like this failure narrative, and is that maybe also failure of the media, or is this the failure of the UN, or like what like moving forward, like what could change in your opinion in that sense?
Well, that's a little bit of a tricky question. The one thing that I wanted to emphasize is that it's not necessarily that the Security Council is failing. It's that it's a reflection that it's failing. And of course, what has to be mentioned is that, I mean, I don't want to generalize, but bad news sells better in some instance, especially when it's the Security Council. The headlines are much stronger, are much more prominent than when the Security Council agrees on something. As to moving forward, well, I'm not really sure how one can move forward with this, because the media coverage of the Security Council, I mean, the media is very much a reflection of society as well, of what we're interested in. So I mean, what would be the solution there? That it should report every time the Security Council manages to do something, but that doesn't detract from the fact that the Security Council does get things done. But I guess a question to contemplate is indeed one can move forward. But certainly, I think despite what we see in the media, it doesn't mean, this prognosis that the Security Council is dying, I think is not correct. And doesn't matter how many papers are published that the Security Council is finished, it's not, it continues to work.
Thanks, Marco. I actually have a question that for you that kind of piggybacks off Henning's question. So you touched on the media coverage of the Security Council response to the conflict in Gaza, and I just wanted to get your views on what you think the potential long-term influence that media coverage of the Security Council's deadlock, as well as the resolution that's now been passed, might have on public perceptions of its efficacy and functionality, and what this might mean for it as an institution, if anything.
Well, I think in terms of long-term effects, we have examples of this particularly from the Cold War, or any time the Security Council has in the past had problems to address specific situations. I mean, there's still a lot of research to do, and a lot of it involves empirical research as well. But what I've come to see is that probably the biggest impact that I found is this attribution of Security Council failure to a failure of the entire UN system, without considering that the Security Council is one part of the system. So I think I would say that that's probably the biggest long-term consequence. And with the situation between, in Gaza, I mean, I had on one of the slides with the situation several decades ago, and it just shows it's a repeat, where the Security Council can't seem to reach consensus on a specific situation. That's picked up in the media, and many of these headlines you will see that they don't necessarily say the Security Council fails, but they could simply say the UN. One would need to pan through properly into the article to find out exactly what they're saying, but there is this attribution, this general attribution. So when the Security Council fails, it's not only the Security Council, but it's the entire UN system that has failed.
Thank you for that. Ivan, did you have a hand up, or?
I just was going to do a follow-up too. I think we both thought of a quick follow-up. And I'll be very brief, Marco. I recently published a small piece on potential reforms of the UN Security Council based on the conflict of Russia and Ukraine, and how that exposed what has been seen in the past many times of it being blocked whenever one of the big interests of the five permanent members is at stake. Do you think there is any realistic possibility to reform the UN Security Council, or is this the best that we can do? And it's just good that we have this because we didn't used to have this even.
Thank you. I think, we shouldn't be complacent and just accept things as they are. But I think it's what we have at the moment. And I don't really think that we would see, because any kind of reform would require severe or massive concessions from the Security Council, concessions that we're unlikely to see from any of the permanent five. There was, I think it was in the 1990s, where there was some sort of push, particularly for India to have a seat, for Brazil to have a seat, and I think at some point even Germany to have a seat. I don't think the question was open for them to have permanent seats, but simply to expand the size of the council. But the divided on many issues. I'm not convinced that adding more members is going to fix the problem, because usually the way they vote, they vote either in one or another camp, the P3 versus the P2, and the non-permanent members occasionally fall into one or two of these camps. But I'm just not sure how adding more seats won't just have the same thing happen again. And on many, something like the situation in the Middle East that we see ongoing, there is a very clear distinction. There is either A or B. The same with the situation in Ukraine, or the Russian invasion of Ukraine. There is A or B. But with many other matters that the Security Council takes, it's not simply an A or a B. There are so many different perspectives on it. And when you look at the voting, particularly the abstentions, that's when you kind of get the idea that there is not always this one or the other side. And if you can't have 15, or you have a situation where 15 member states can't agree on something, what are we going to do with 17 or 18 or 20 member states where there could be even more potential for disagreement? Yeah.
And let me add to that something that I wrote, which is I don't think the problem. I mean, I don't think the problem is adding or not. The problem is you still have vetoes which are not subjected to any sort of conflict of interest. So then you can vote on something that is against you, as Russia did with Ukraine, and that's it. So there's no conflict of interest that can exclude a voting power. And so I think what India, Brazil, Germany want to do is just have that power, not necessarily make the system work any better. But yeah, let's try to be optimistic anyway.
If I could add to that, what you just mentioned, I agree as well. But I think it's because of the times that we see, and I guess to a certain extent the coverage in the media, is we seem to, I mean, we're not really in desperate times, but our view sometimes the Security Council can become desperate, especially when it doesn't work out in a specific situation. So then we start to reignite really crucial and substantial debates, such as Security Council reform. And then we seem to place added expectations, which we delve into a lot, but without really any practical possibility. For example, with the situation in Ukraine, some time ago, I think it was last year, where there was really big debates on two specific topics. And that was the voting procedure of the Security Council under, I think it's Article 27, that Russia shouldn't be able to vote when, when the Security Council takes up a matter where one of the members is involved in that situation, then specifically that situation, they're not supposed to vote. But we have the well-established practice of the Security Council that these members do vote. The black letter law of the UN Charter we've moved beyond that. And another topic also on the situation in Ukraine is whether Russia can be expelled from the Security Council. And there was very good posts and analysis on this, but practically speaking, it's something that's very unlikely to happen. So we're again reverting to some more, let's say, desperate views, grabbing something that is not really realistic in terms of reform or changing or even modifying the way we actually see the Security Council.
Thank you both. We just have a question in the meeting chat as well. It's in relation to the last presentation, and it's from Emmanuel. The question is, in your recommendation, you said that UA only require unilateral acts to be valid. Can you expand on that, please, or did I miss something?
Yeah, sure. Perhaps we didn't portray it very well, but we were talking about the fact that UAs only have a publicity requirement, not any other formal requirement. So they could be made, for instance, orally, they could be made in written form. So the only thing that a unilateral acts need to have in order to be binding is to be public. It should be known by the public. This was studied by the Court of International Justice in several cases. For instance, the ones surrounding the nuclear cases with France, and the declarations that the president and the Minister of International Affairs did. So yeah, maybe that clarifies it a little bit. But the only thing that unilateral acts require to be valid and binding is this publicity.
Thank you for that. Were there any final questions for any of the panelists before we conclude today? Excellent. Well, we'll conclude there. Thank you very much to each of the panelists for such excellent presentations and discussion that followed, and for everyone that came along to watch. I will close off this breakout room in a moment. We have some concluding remarks in the main meeting room that will commence in a couple of moments. So I'll see you all back there for that. But thank you very much.
Thank you, Jaja.
Thank you.
Thank you very much.